Hi all. Hi, I'm excited. This is Traci KAAS. I'll wait, kind of talk a few minutes just to let everybody kind of come in to the seminar. We're super excited. So we'll just give it 1 minute as we kind of talk it through. But it's a beautiful day. It's Thursday. Hope everybody is staying happy and healthy and doing really, really well. But I'm Traci KAAS and I am the settlement planner. I'm a financial advisor and a financial transitionist and author of What You Can Expect When Expecting a Settlement and also of the Attorney Reference Guide. So at the end of the seminar and or during the chat, I will also put my information in. So if you would like a free copy of either one of those books, just let me know. But today I am very, very excited. One of the most challenging types of cases that I do are cases that involve traumatic brain injuries. The client is competent enough or just has memory loss issues or just needs a little bit of help. These are incredibly complicated cases and can be very, very tricky, both for me as a settlement planner and for the attorneys. And so today I really wanted to start this inaugural seminar off with somebody who is absolutely amazing and understands these TBI cases so well, so well. And so when we work together, it's just a fun synergy because we're protecting ourselves, we're protecting the clients, and in the end, everybody's super, super happy. So incredibly blessed and very, very lucky to have Tina Ojagian joining me today. Tina is one of the top TBI attorneys in Southern California. She has record-breaking settlements and awards. She's over $55 million already this year in 2020 during COVID. Really, Tina, you're gonna have to tell us more about that. You know that you live and breathe the TBI world. I'm super excited to hear more about that. You are on probably more boards than I can count, more speaking engagements. You're heavily sought after, and I'm so lucky to have you today. Also the founder of the Brain SoCal. I'd love to hear a little bit more about that today as we talk as well. You run an incredibly successful practice. Every time I talk to any of your employees, they're happy to be with you all the time. So your employees are happy. You have your beautiful family. Your kids are fantastic, and you're one of the best fashionistas that I know. So welcome and thank you for joining me today.
Thank you so much for having me, Traci. I adore you. I'm so proud of you. You are definitely the preeminent structure broker in your field and financial planner. And I'm just really honored that you asked me to come on, and I'm really glad to be here. So thank you for having me.
Yeah, I'm excited. Today, for the audience too, when Tina and I talked a little earlier, we decided to go an unscripted type of seminar so that we're kind of just more casual, pop in your questions and your Q&A, and we'll get to those at the end of the day too. I have a couple slides that I might touch on, but overall today is kind of an open conversation and we're just kind of going to see where it goes. Tina, tell me first, just to get to know you a little bit more, what made you gravitate towards working with these types of clients? Because they're incredibly challenging. It's not the run-of-the-mill types of clients. What really drew you to this type of client?
So yes, welcome to Tina and Traci Unscripted. It'll be fun and it'll be funny, but hopefully you'll get some good pearls of wisdom out of it too. So I started out as a defense attorney at a time where we were in the middle of a recession and legal jobs were really hard to come by. And I always felt like my heart wasn't in it, like I was on the wrong side. And one day when I was in court, I ran into this woman who was crying and asked me if I would help her. I was in regular clothes. I didn't look like an attorney. And she told me that her husband had fallen off the roof and their attorney was trying to force them to make them sign papers to settle their case. I think it was for like $100,000 or something back then. And that just struck me as wrong. And I felt like I'd done the defense side of it, which gave me a unique perspective, and I can do this and I can do right by this man and do so much better than his attorney was at the time. So we ended up taking that case and getting a great result. That was maybe 15 years ago. But I still didn't really quite understand like God's plan and why I'd fall into this sub niche of like brain injury litigation until like 5 years ago. My mom had a massive stroke on my birthday while I was out of the country.
Oh my God.
And And so my life was forever changed. The doctor told us that she wasn't going to make it. And so it was 36 hours on Bastille Day of trying to catch a flight from France to the States and talking and reaching out to all of my resources in the brain injury community until this guardian angel finally went and saw my mom and transported her to a rehab hospital, pegged her, and then spent the next 3 years nursing her back to health. And my mom is still alive today. So if there was ever a doubt as to why I, had fallen into this community, into the brain injury community, I think it was clarified at that point for me. And so I feel incredibly blessed to, and it's close to home for me, but I feel incredibly blessed to be able to represent these folks whose lives are forever changed by this type of injury. So
that's amazing. Thank you for sharing the story, because I know it had both a professional and a personal side to it too. And I feel as if when I come across people, when they love what they do, they usually have a story that almost hits home more than, well, it's a good job or it pays well or something like that. When you've got a connection, a personal connection like that, I think you just, you're all in. And that's kind of my words, is you're all in. I try to pick a word every single year that I try to gravitate towards. And my word last year was just being engaged and fully engaged 100%. So thanks for sharing that. What on this topic, it gets really, really tough to understand what are kind of some of the symptoms or some of the toughest issues with these TBI cases versus different types of cases, that as to why we're doing a special seminar on TBI versus just general supplement planning.
So TBI cases are incredibly difficult. They're incredibly rewarding because you're getting to help someone at a time in their life when they need it the most. But that's like a two-part question. So the first part is, why is it so difficult? It's because brain injuries, by and large, are invisible, right? And you can't see them from the outside looking in. Mild traumatic brain injury cases, even more so. You've got folks that look like me and you, and if you have a brief conversation or interaction with them, they seem just fine. But they've got like these maddening, constant symptoms that no one can see. Oftentimes, people don't believe them. Some of the times, they lack insight into their own injury. So you're dealing with people who are really messed up, who don't know how messed up they are. Others can't see how messed up they are, and it is my job to make sure that they get a fair shake, okay? But as far as symptoms go, I do this like really extensive symptoms checklist with them in my intake, and I don't only do it with them, but I do it with their loved ones, the person most knowledgeable about them, because oftentimes either they're amnesic to what's going on, or their judgment's a little off. They don't quite perceive themselves as they are. And so it's really helpful for me to get from the person who knows most about them how they've changed as a result of the injury. But if I had to sort of summarize the symptoms, I guess I would say, there are the physical symptoms, which are the chronic pain, debilitating headaches, the tinnitus, the ringing in the ears. There's loss of taste and smell. There is, sometimes loss of strength in the extremities, depending on, what type of brain injury, what region of the brain is affected. And then secondarily, you've got like the cognitive issues. And those are the ones where, you've got memory issues, learning disabilities. The processor isn't working quite the same as it used to. So you've got slowed processing, difficulty word finding, executive dysfunction. A lot of folks who've had frontal lobe injury have executive dysfunction. And so, you've got impulse control issues. And that leads into the third type of symptoms, which are like the emotional symptoms. And that's, depression, anxiety. I've got folks who've had suicidal ideations, multiple personality disorder even. And so when you've got the myriad of these types of symptoms interplaying, it becomes really difficult. And brain injuries are like a disease process. So they don't just affect one part of your body. So it's very common for folks who've got the emotional, the cognitive, and the physical symptoms to also have like internal issues, right? They develop pituitary dysfunction as a result of the brain injury. And so their hormones aren't quite right. And so you got to look into that. They can develop urological issues, sexual dysfunction issues. And so I try to take a whole person approach and make sure that all of the proper specialties are consulted so that I can contemplate everything my client needs to get better and, to kind of ascertain the value of what they're going to need for the rest of their life.
Yeah, and that's amazing because especially so many of these have anger management issues as well. And so your intake includes bringing in the family and hearing what the family says, because again, they're not able, the client themselves cannot articulate, and so it probably that bigger question of how were you prior to or after. And I'm finding more and more, I keep encouraging people to use their videos more and more just in life, because you really on video get to see this is how you acted before, this is how you're acting after. When you're doing the intake in right now with COVID, are you still finding on your new case intake that you're having the people come in with their families, or are you able to kind of do this well through Zoom and this way?
I am willing to go out to my clients, and honestly, like, I prefer it. I want to see their environment. I want to see how they live and the interplay and the family dynamics, because it helps me do a better job of representing them. There are a small fraction of clients that don't feel comfortable with that, and so we are able to accommodate them via Zoom. I also try to be mindful that, there's some research that's come out now with folks with brain injury. They can be more susceptible to the long-term effects of contracting the coronavirus, and so they are technically a little more high risk. So I don't want to do anything to endanger them. So we get tested on a regular basis, but the preference is to see them and their family members in their own environment, and to go to them. But if we can't do that just yet, there are probably, I would say, like 3 or 4 clients that we've spoken to via Zoom and done the thorough intake via Zoom, just to be on the safe side. I love meeting with the family, because the thing that I get the most is, this person just isn't who they used to be before. And that's sort of a great opener to say, okay, well, tell me how. And then you start to get really the insight of what's changed, and you can convey that to the experts and the treaters in the case, so that it becomes part of the record for the trier of fact down the road,
Yeah, and I find that you and your office are very hands-on, and what I see with that is, especially with these TBIs, is having that hands-on is you get to see them often, and you talk to them often, because it's each time you talk to them that you find out they're like, oh, there it is. Because you may talk to them once or twice and not quite see it, and then all of a sudden there it is, or it's on that text, or it's on.
Exactly. That's why, expert opinions are so tricky, because they get to see your client for like this little sliver of time in this prosthetic environment, and they may not necessarily catch it. And so they may claim your client's lying, or they're malingering, or, so I think that that's really important.
Yeah, it is. It is. How do you, these cases, again, being just so unique, how do you work them up or prove them up? I mean, do you have like a strategy? I know each case is a little different, but I'm sure that you probably have some sort of process.
So here's the thing. Look, it's funny because I get asked this question a lot, especially by new attorneys. I feel like they're looking for a formula to implement every time that's like foolproof, that's going to give them an outstanding result. Unfortunately, litigation in general, but particularly brain injury litigation, doesn't work like that, because every brain injury is different. You can have the exact same mechanism of injury, but it can manifest in completely different ways in two people, depending on their comorbidities, their premorbidities, and what's going on in their life. So the thing that I do, or the approach strategy that I use, is I don't take a cookie cutter approach. I tailor make my litigation plan in accordance with the nuances of every case and the needs of every specific client. So I've got colleagues that I love and respect that, have a go-to neurologist that they will retain on every brain injury case. And, that'll be their, star medical expert and so forth. I don't quite work that way. I'll give you an example. So I recently got brought in on a case right before trial, because, the plaintiffs wanted like another set of eyes on it. They wanted a female attorney on it. And I took a look at it, and the attorneys who had it before me came through me through another attorney, but the attorneys who actually had the case before me are guys that I respect very much. They do great work. but reasonable minds, obviously can differ. And it's amazing to see how different everyone's style is. So I took a look at their expert designations first and foremost. I'll tell you a little bit about the plaintiffs. So my plaintiff had a really bad car accident and a brain injury as a result of the accident. It was actually moderate to severe brain injury because it showed up on a radiograph. Mild TBIs by definition don't show up oftentimes, most times. Some would say all the time. So she had a really bad brain injury and has had all sorts of sequelae as a result of it. The problem is she had some life circumstances. And so, there were some lies that were told to various doctors and some inconsistencies that were captured in a deposition, which really muddied the water and muddied just how bad this injury was and took away, prejudicial and took away from the validity of her injury. So looking at these expert designations, and they had designated a neuroradiologist and a neurosurgeon, and that was it as far as medical experts went. And I thought, that would be great if we didn't have all these other issues hanging out, which now we have to rely on recipient witnesses to kind of explain away, like, lay witnesses as opposed to experts. Neurosurgeons and neuroradiologists, I know, are super dry and scientific for the most part, right? And their testimony, the most exciting it gets, I think, is when they show you like the colorful, pretty images of like the axonal shears of the different colors and explain, the brain injury and so forth, but it doesn't really go beyond that. And in this particular case, I elected to redesignate experts. I designated a physiatrist, a physical medicine and a neuro rehab doctor, which I think is an underused and underappreciated specialty in brain injury litigation. Now, do I use them in all my cases? No, I use them probably in a small handful of cases, but this particular specialty, they're an MD, but they take a whole person approach and they take a look at the psychological profile, and they can explain why, the client behaved the way they did, and they can kind of humanize them and tell their story a lot better than like a neurosurgeon or a neuroradiologist. I then also designated a neuropsychologist, and I think my predecessors probably hadn't done that because they didn't want to open up, Pandora's box of all the stuff that had happened. But the problem is that's already all on the record, right? Through the depositions and the medical records. I just need someone to explain it and say, she's not this conniving, manipulative, lying plaintiff. She's afraid. She's paranoid. She has unrealistic fears and, and impulse control. And this is all a result of the brain injury. It's exacerbated by the brain injury. And just, again, be able to like humanize her and tell her story in a way that she'll get a fair shake. So that's just sort of one example of, I know that there's some attorneys say no neuropsych testing ever, that opens up Pandora's box, or yes, always neuropsych testing. I don't like to take that approach because I think every brain injury is different. Every client's circumstance is different. The set of bad facts in every case are different. And so I tailor make my, my litigation plan according to that. Secondly, I would say that I don't really spare any time or expense in working up the cases. So as far as tools, obviously, first and foremost, radiographs, I invest in, 3T MRIs and other like neuroquantitative studies and, all sorts of cutting edge stuff to get to the bottom of what's going on with my client. I send them to multi-specialists. If I know there's internal urological issues, I don't rely on the neurologist's opinion of that. I get it properly, thoroughly worked up. That way, my workup can be comprehensive and I can add value and I can make sure that in my life care plan, I don't leave any money on the table.
So do you use some of those tools, the life care plan and stuff too? I know you do some work, workers' comp as well as some TBI cases. Are you using these additional tools? Because a lot of times when I work on a workers' comp case, just spending the little extra money, and sometimes you're spending the money just to push the case and doing these other things because the workers' comp defense they're not going to pay for it. Are you using these same tools on the workers' comp cases as you are on liability cases?
I'm using the exact same tools. Yes, I get voc rehab experts and economists to talk about loss of earnings. I even get biomechanical experts. I know a lot of people think, well, liability is not contested in workers' comp. It doesn't work like that. A lot of times it is. The mechanism of injury is contested when they're looking at such a large exposure case. And, so I use biomechanics on my cases. I use both rehab experts, as I said, functional capacity evaluators, life care plans on every single case. Because, this idea on the civil side, some colleagues will say, well, we'll take the meds, we'll triple them and we'll make a demand. Or like in workers' comp, they just kind of eyeball it. That to me is like malpractice waiting to happen on a brain injury case. Because again, the nuances and the needs are so different and so complicated. And, it's so multifaceted. You have to account for everything. And I just feel like better be safe and rely on a life care planner and involve them. And sometimes I'll check their work, like I'll cross-reference what it is they're projecting with what the carriers actually paid on the workers' comp side or on the civil side, what they're projecting compared to, what I've seen in my experience of, well, what about this? Well, you don't mention this. And so I just really make sure that it's realistic but comprehensive.
Yeah, and maybe we're putting in, the bathroom sink, not the kitchen sink, in everything,
Exactly.
As well. So one of the interesting things is, you're very, very well versed in some of the medical and that kind of stuff too. So if you are an attorney who would like to work on some of these types of cases, but a little nervous of the medical and, the big words, if you will, and just understanding it, where did you get your comfort level of having this level of conversation? Because it's a lot. And I think a lot of times they're not bringing in some of the experts because they actually have to, somebody has to have a conversation with the expert and feel comfortable that they're having an intelligent conversation. And so where did you get that level, and what advice would you give to somebody to get comfortable with it?
You know what, Tracy, I'm a little bit of a nerd, and
No, I don't. I can't say that.
I definitely am. And if I didn't faint at the sight of blood, I probably would have ended up in med school. And so, I'm just genuinely interested in the intricacies of the way the brain works. I think it's fascinating. It's like no other organ in the body. But I've been attending brain injury education seminars and brain injury conferences since 15 years ago, before it was even on the radar of the legal community, because it all of a sudden got sexy after the football CTE cases. But prior to that, it was just kind of 10 years behind the medicine even, right? They just thought it was a regular injury, like a broken bone, it heals, you're all better, and there's no residual and you're done. And so, brain injury cases were undiagnosed and undervalued way more commonly than they are now. And so I think, the Malcolm Gladwell book, I forget which one it is now, but it talks about like the 10,000 hours before you get proficient at something. I've been eating and breathing this for a couple of decades now. And so I can't tell you the number of times I'm in deposition or I'm brought in just to take the defense expert deposition. And then the doctors will ask me after, do you have a medical background, or, have you, and it's kind of funny to me. I take it as a compliment, but, I wish I could tell you that it came naturally, but it's been years and years of, education and staying on top of and self-education to make sure that I can do these people justice,
Yeah, and I think that probably goes back to, the beginning of this conversation is, finding that you have a purpose in it and connecting to it. And because you love it, you're all in, you're engaged, and so I think that's one of the biggest things is don't try to, do a TBI case if your heart is in a different type of law or a different type of case. If you're an employment attorney and you came across an amazing TBI case, your heart's probably not there. So maybe not try because it looks good. That's when you would partner, right?
It's not even, don't try because your heart's not in it. It's funny. I clerked for Judge Terizian, who's just amazing. He's a federal court judge and mediator now in law school. And the most valuable lesson I got from him, other than like sitting in chambers and watching him and Girardi and some of the other attorneys back then go at it in these intense settlement conferences, I learned so much more than I did in law school, just from that practical experience. But the one thing he left me with is, kid, stick to what you know, specialize, so you don't get sued. And so, I kind of think that it's not like med school where you get to specialize in your field. And I almost feel like it should be. We get to do whatever we want once we get a license. It's really important to kind of specialize and find a niche or two and master that and be, and avoid, I guess, being jack of all trades and master of none, And so I can't tell you, we probably refer out 97% of the cases that come through our door, workers' comp or civil, because they're not, in the realm of brain injury. I think we've got a few spinal cord injury cases involving like quads, some severe PTSD cases like shooting victims, but like 98% of our cases are TBI. So
do you find that, because I'm kind of going back to, when you're in trial and talking when the doctors are boring and such too. However, I think that I feel like the taboo conversations, obviously I talk about money, which is totally taboo all the time. And then now with all of the racial things happening in 2020, but then also having a TBI or having any mental issues or unseen things, this is kind of coming out a little bit more. Do you find that, and kind of going back to what you said about bringing in the right doctors to explain, because I think you're going to have a jury, that juries are now starting to be able, it's okay, I've had issues too. I've had, an accident before, or I've had depression before. And so I think you're probably trying to pull that out a little bit more. Do you find that you're pulling that out a little more with the juries, that it's okay, this isn't a taboo conversation to talk about a TBI?
It's absolutely not a taboo conversation. I hear what you're saying though, but in those types of cases, I think it's really important. Again, we're talking about like bad facts, right? And so you want to not shy away from them, be aware of them, and then explain them during the course of the trial as best you can. I come in on the medical expert side of things and dealing with, medical experts. And I partner with other attorneys a lot of times, and they're handling sort of the lay witnesses and stuff. And so with the doctors, they are there to speak on the issue of brain injury. And so taboo or not aside, I think the only taboo is like, are they exaggerating? Are they feigning? Because that's almost always the argument of the defense, right? Mm-hmm. And so I think trying to explain, look, there's a baseline. Yes, we all have issues, but not like this. This is different because, and then bring the neuropsychologist into it. Like, how is it different? How have they changed? How this could happen to any single one of us, I think my clients really struggle with the stigma also. And so there's a lot of like, macho male, certain ethnicity clients who will downplay their symptoms. And so I think it's a struggle with them to make sure that I keep them honest, so the trier of fact can really see. And, whether I elect to put them on the stand or not, that again is a case-by-case determination, but for the trier of fact to really be able to see, I can't have them be downplaying their symptoms to the experts or to the trier of fact. And sometimes that's a challenge too.
Yeah. So when you're working with a client, it's always a touchy conversation because I'm fine. There's nothing wrong with me. Yeah, or, so how do you approach, so you're getting to the point of settlement and that you need to protect the client, but how do you have that conversation with them of, kind of saying, we need to protect you from you as well as protecting you from other people? Because that's always a delicate balance. I've always found it a little hard because especially we need to protect you from you conversation. Mm-hmm. How do you approach that?
So I think this is where having a rapport with your client and their family and having good client control is really important. And some younger colleagues think client control is you yell at your client and they listen to you. That's not what I mean. I think they need to trust you and respect you. I have found that if I bring them in and explain to them, take the time to actually explain to them and their family the nuances, I'm able to get their guard down. Now, let's be honest, a mentally healthy person doesn't like having someone else in charge of managing their money. I know I don't, I'm always micromanaging my financial planner. Like, what are you investing in? What are you doing again? Why is this say this? Why is that say that? So,
They're thinking you're
You know,
crazy for that.
I know. And so, I can't fault my brain injured client for being paranoid about having a total stranger manage their money. And so I go through this whole list of issues that are very real and apply to almost every case in this narrow scenario. And I tell them, look, first of all, the likelihood of a judge approving a settlement for like $8 million or $9 million and handing a brain injured, cognitively compromised individual a bag of cash without protective measures in place is slim to none. So, that's one reason, particularly on the workers' comp cases, that you need to consider having a protective instrument in place. Number two is, you've been through enough already, and I want you to focus on getting better and staying healthy. The last thing I want is for you to now have to worry about paying bills and paying medical bills and, managing your credit so that, you don't tarnish your credit score. And thirdly, I want, you to focus on being a family rather than have that strain put on you and your family of now having to have a loved one in charge of your money, unless there's a guardian ad litem, and then that's a different conversation. If they've got kids or dependents, I like to appeal to that as well and say, look, this has happened to you. I know you feel, a lot of times they feel like less of a person because they're not able to provide. And so I tell them, this is your contribution and your way to provide, and you want to preserve and stretch these proceeds as much as you can. And lastly, this applies to some of my ethnic clients. I tell them, look, you're a target. You just got this ton of money, and a lot of this is public records. And so you're going to have all sorts of people hitting you up for cash regularly. And you really need to, and you're susceptible and you're a nice person. You're going to want to help them. And so it would be nice for you to have someone there to basically make sure these proceeds aren't squandered, save them on your behalf, invest them on your behalf. And so when you kind of put it to them like that, there's little they can say to sort of disagree. I also like to get the doctors involved, the treaters involved, because honestly, that's not a determination that I want to make on my own. I don't take someone's ability to have control over their person or their money lightly. I don't like to make that on my own without, medical consultation. And so I get capacity declarations a lot of times.
Good. Now, do you have kind of an outtake? Like, so there's obviously the intake, are you on government benefits and that kind of thing, but a lot of times you're working early on a case. At the end, do you kind of do an outtake just to better understand whether they're on, whether they're on Medicare or whether they're not on Medicare or those types of things? Sometimes you find out if they're a citizen or not because the planning can be a little bit different. And so how do you guys, at what point do you kind of dig into what government benefits that maybe that they're on, or if you need to deal?
Yeah, I think I understand the question. So we do an outtake, and that's kind of part of the same discussion of, is this person going to be protected enough with a structured settlement? In other words, if the doctors determine that they're of sound mind to manage their own money, which is a fine line because they're cognitively impaired, I guess if it's mild enough and they've got enough protective coping mechanisms that they're taught, that they're able to employ on a regular basis, they should be fine. In those cases, at the very least, I always do a structured settlement, never lump sum, because at least if they have a bad month and they go to Vegas and blow their money, I know at the end of that period, they're going to get another check. But again, most of my cases, I have at the very least a guardian ad litem. And the decision, the way that we make the decision goes a little something like this. I am very close with my clients and their families because, as you know, it requires a lot of hand-holding. I'm their attorney, I'm their case manager, I'm their therapist, and their family therapist. And so in regular marriages, the divorce rate's 50%. In brain injury cases, it's closer to 80 because nobody signed up for that. And even if good intentions at first, they're just waiting for the settlement to happen so they can bail. I don't mean to be cynical, but I've seen that so many times. And so, unless I feel totally confident that this has been a spouse that's been by my client's side and always acting in their best interest, and the neuropsychologist or the treating physician agree with me, I'll always bring in a professional fiduciary. But if we've got a situation like that, I at least get a guardian ad litem for the purpose of stepping into their shoes for settlement and resolution of the case. But then, a lot of times that's not the case. And so you have to think about bringing in a professional fiduciary. I like conservatorships, but after talking to you, I'm going to reconsider. I like conservatorships because honestly, they're easier for me to explain to my client, like that this person's bonded and insured, but more importantly, there's court oversight annually to make sure that, they're not mishandling your money. And I like the fact that you can use proceeds of a conservatorship to pay for your, family vacation, to pay for your kids' college education. I find it to be less restrictive in that way. But I do have some clients that are on, Medicare or other entitlements. And in order to preserve those entitlements, I can't have the proceeds of their settlement count as income, right? And so
Right.
I do elect to do needs-based trusts in those narrow scenarios, like a special needs trust or so forth. But you are the expert in this, and so I want to hear your thoughts on it.
Well, I have lots of thoughts on that one. But some of I think each case is individual and one by one, and there is no cookie cutter as to how every case is, because it honestly is the dynamic, the amount of money, the family situation, do they have support? But I kind of go through, I am gonna show a slide real quick. And just so I can show a little bit here is one of the things I kind of start with the basics, and because this is going to end with how do I determine if I should do a conservatorship or a special needs trust, and I'll touch on that real quick too. But one of the number one things to start out with is it's very confusing for most attorneys and most people when you ask them what kind of benefits do you want, they just call it Social Security. So is it SSI or is it SSDI? And that makes a huge difference. If somebody's only on the SSI, then we can maybe just do the conservatorship. If somebody's on SSI, we definitely want to talk about a special needs trust. I believe, of course, every single attorney should always, even if they can be with their client, always go to ssa.gov and pull their statement of benefits, because the statement of benefits is going to immediately tell you if there's any chance that they're going to be on Social Security disability income, or it's going to say very clearly you have earned enough credits, or it's going to say you have not earned enough credits. If somebody has earned enough credits for Social Security disability, they're going to get Medicare, and potentially a conservatorship might be the right answer. If somebody is not, they may apply for SSI, Supplemental Security Income, and then they'll get Medi-Cal as a secondary, even to potentially the workers' comp claim and or the settlement. This is a great snapshot. If anybody's got their camera and taking a picture, this is the picture to take. There's two different types of benefits. There's entitlement benefits. The easiest way to think through that is it something that I would probably be on myself? Social Security, Medicare, things that you're going to be on yourself, most of the people on this call, and that comes out of FICA, that comes out of your check. You're entitled to receive those benefits if you have a disability. So those are not affected by giving somebody a settlement. On the other hand, if somebody is on Supplemental Security Income, Medi-Cal, you hear the words welfare, you hear the word food stamp, you hear the word low-income housing. One of the other things that people really need to pay attention to is if somebody in the house has a disability, that's something else we need to kind of take care of as well. And the number is $2,000 for an individual person or $3,000 for a family. If you're receiving more than $2,000 or $3,000 and you give them a check, you potentially could have issues with your client calling you later saying you've disqualified the benefits. There's different options to protect the benefits. As you mentioned, Tina, a conservatorship. A conservatorship is going to be court ordered. Some of the positives are it can be somewhat a little more flexible with some of the expenditures. With that said, every expenditure has to be approved by the court. There are certain things You don't have to go every single day, but in 1 year and then every 2 years for the lifetime of the beneficiary, you're going to have to show the judge where you spent the money. So you have to kind of wonder if that makes sense. And sometimes it absolutely does. It gives you a little bit more flexibility, but you lose the flexibility of having the court kind of watch over everything. There's something called a settlement preservation trust. And what that is that gives the client the ability just to have a trustee, somebody that has 100% the check writing abilities. So they don't have control of the funds, but they do, because usually they're going to receive what's called a debit card, and they do their expenditures off the debit card. This week, I am working on a case right now that I can talk about a little bit later. But this is a brain injury. It was a motorcycle accident, and he has a TBI, and he thinks it's fine. And it literally took me the third phone call before I saw his TBI. Within that TBI, we are going to do where his mother is going to be a co-trustee on just a revocable living trust just until he's 30 years old. A special needs trust or a pooled trust, those are trusts that you can utilize that will protect needs-based benefits. So on the types of settlements, Tina, that you've done everything you can to get as much money as possible. However, it's just not quite enough. And so they need that Medi-Cal as the supplemental in health insurance. Most people just don't realize that unless you buy a private long-term care policy, Medi-Cal is the only place that you could receive long-term care. So attendant care, somebody coming into your house. So that's super important to look at that. A pooled trust, if you have a client that's over 65, that kind of thing. So there's different options there too. Whenever you're settling the case, I'm a huge advocate. The client's like, I'm fine. You probably heard this one a million times. I'm fine. I don't need any help. Just give me my lump sum. I'm done. These are different disclaimers that we work with, that we do share with attorneys all the time. And you can share with your client. You can always email. I'll get these to you as well. But if somebody doesn't want a structured settlement, I probably should explain what that is in a second. If somebody said, you know for a fact they're on government benefits, and they're like, I don't care, I still want my money. Or a Medicare set aside, and they're like, I don't care, I just still want my money. There's disclaimers for that. And you would be shocked, as they're reading these different disclaimers, they're making that decision to make the proper choice. You know, just because when you're having somebody sign off on a document that I fully understand that I'm throwing away my benefits, I fully understand that I'm fully responsible for everything, I gave up this good thing. And so that way everybody's a little more protected, and that helps when I'm having the conversation, you know, to get them there. But there's so many different tools, and utilizing what is a structured settlement for those on the call that don't know. A structured settlement is a guaranteed income stream that the money goes directly from the defendant, so it doesn't touch the client's hands, directly from the defendant to the annuity carrier like USAA, New York Life, Metropolitan Life, Prudential, those types of companies. So the clients can feel very, very comfortable. One of the other things that I do often, it works really well for the independents, is if you're not worried about needs-based benefits, and we don't have to have court approval, and yet there's a need for a lump sum, but you want the client to have some independence, what we will do is create an income stream of annuity payments that go directly to the client, whereas a lump sum may actually be in a trust of some sort, where there's a trustee that helps them to monitor and manage the funds that are in the lump sum form. But then they have a guaranteed income stream that helps them to feel more comfortable having some independence. So those are just some different ways that we work through it, but we can go on and on about, as you can see, that's my passion, right? So that's kind of different tools that I think that can be used. And I think that's why I enjoy working with you and the attorneys that really understand the settlement planning, because back to I don't know that it's taboo, but I think that there's a fear of finding that fine line between what is the responsibility of the attorney to educate them on what their options are and or protect them. You know, is my job just to get I'm curious on your thoughts on that, is it your job just to get the settlement done to the best that you can, or is it your job to make sure they're finished out? What are your thoughts on that?
No, my job is absolutely to make sure that those funds are preserved. The last thing you want to do is, leave your brain injured client susceptible to abuse or those funds being squandered. But yeah, no, I always get, I didn't explain this, but I don't draft the conservatorships myself. I retain and pay for a probate lawyer to do that for me, to draw up the instrument for me prior to settlement of the case so that the instrument is intact to receive the proceeds of the settlement. I also get capacity declarations to protect my client, but also to protect myself down the road if, we decide to give my client a little bit more latitude and control over their own money. And just elect to go with a guardian ad litemship and not a fiduciary instrument. So, but I also, it's funny, those releases that you showed for my client to sign, we have one of those in every case. It says, I have had a thorough discussion with my client about my options and how to receive this money. I am aware that this is what the doctors are recommending. I'm electing to have my wife serve as the guardian ad litem as the doctor has recommended. And I think we've had like one or two cases where they declined. In one of the cases, the judge stepped in and said, look, I'm not going to approve the compromise and release with you in charge. And in another case, they received it, but we definitely have, those letters kind of disclosing everything properly and protecting everyone's interests so that everyone's clear as to, how we came to the decision to do things the way that we did.
Yeah, and I think that that's where having, I talk a lot, one of my favorite words is a brain trust. Having a brain trust, and sometimes you have multiple brain trusts. Sometimes you have the legal workup brain trust, and then you have your settlement planning brain trust. And so when you have that relationship, you also are, again, educating the clients, protecting yourself, but now you've got another layer of protection. And I feel like TBI cases are the number one layer that you have to bring in a team. And there are cases, I had an attorney, there's an attorney in Orange County who, of course, this was maybe 5 years ago, was trying to be sued. The client was trying to sue him because he got him a very good result. He spent all the money in a very short amount of time, because statistics still show that people will spend the money inappropriately in a very short amount of time. Then he came back, and this is what he said. He said, well, he goes, you knew that I had a TBI and you still gave me my money. If you knew I had a TBI, why did you give me all the cash? And fortunately, that attorney had a settlement planner who also had, no, we had you meet with a settlement planner. You looked at the structured settlement options and you signed a disclaimer. So there wasn't anything, in the case, of course, went away, because there is that really fine line of making sure, especially in the state of California, where, having somebody conserved or saying that they are incompetent is incredibly hard to do. And so you can get a guardian ad litem for the case, but sometimes that just isn't enough, because that ends at the end of the case. And so what happens, long term, and again, they may have been having a good month or a good 2 months during the time of settlement, whereas quickly after, sometimes they turn manic or have issues and stuff too. How often, or do you feel that you feel good about your clients later? Are you able to check in with them later, like a year down the road, and see how the plans are working?
Absolutely. So we stay in touch with our clients, and there was one incident where we had just gotten a guardian ad litemship and no professional fiduciary, because the individual was not documented, which there are fiduciaries that will represent, folks that are not documented, but he just, had mentioned that he wants to move back to Mexico and doesn't want to have the restrictions, and that his sister had been wonderful throughout the case. Come to find out that, she was giving him a very small portion, like 10 or 20% of the monthly proceeds, and her family were living off the rest. So he had to go back to court and undo that guardian ad litemship and put in a professional fiduciary after the fact. So yeah, look, TBI cases are, Traci, tough enough as it is, right? I want to leave everyone sort of with the pitfalls to avoid, right?
Yes.
And this is the easiest one to avoid. Call Traci, sure. But, first and foremost, the biggest pitfall is missing it altogether, right? and relying just on those first responders to catch it. Most of the time they won't if it's mild and there's all these other emergent things going on like broken bones and stuff. So altogether missing it for the first year and a half, while the evidence, the medical evidence is basically dwindling down to nothing because, ooh, that was loud. I have a smart house that talks to me. Somebody's at my front gate. Luckily someone else can get it. But, you know, so missing it altogether. I would urge all of my colleagues who've got serious injury cases in their caseload where there was like a catastrophic car accident, the car was totaled, the person was in a coma, or, you know, an induced coma, or had a lot of broken bones, a lot of loss of blood, where there's opportunity for hypoxia, to take another look at the potential for brain injury there. I am willing to bet many of us have cases in our caseload that involve some sort of, you know, mild traumatic brain injury that's gone undiagnosed. That's the first biggest pitfall. The second is grossly undervaluing these cases. So, you know, treating them like they're another soft tissue or orthopedic case and not bringing ourselves up to speed on the medicine. That's something to really sort of be careful of. I can't tell you the number of times I've gotten a case. Actually, just recently we had a case where my predecessor made a demand in the 6 figures on a mild TBI case that was worth closer to 7 or 8. And it took us 3 years to rehabilitate that case. It would have been a lot faster if we'd just done it right from the beginning. But, you know, the last thing you want to do is grossly undervalue an invisible injury case, because that person will more than likely wind up on the street, and they're relying on you. You are their kind of their safety net and their first line of defense. And, you know, being afraid of the bad facts and thinking, you know, you need to contain it and hide it rather than, you know, approaching it head on, because a lot of the bad facts and can be explained away as symptoms of the traumatic brain injury, because they are so multifaceted. And last but definitely most is not protecting your clients' recovery and their assets. One thing I have to say this to you. So I work with a lot of the brokers in our profession because we, you know, all of our cases are catastrophic cases, right, and they're all high dollar value cases at the end of the day. And what I appreciate about you, Traci, is that you don't give me a cookie cutter proposal on every case that involves, you know, this lump sum and monthly, you know, for life, you know, with a 10-year guarantee on it. You really take the time alongside with me and you meet my clients, you find out what their unique needs are, you know, the number of dependents they have, their ages, the family dynamics, who's the primary breadwinner, what are they looking to accomplish, and you tailor make the structure for them in a way, and the financial plan, really, not just the structure for them, in a way that's most beneficial to them. So I commend you for that. I just kind of wanted to put that out there too.
Thank you. Thank you. I think that's my personal platform, is the growing up and just life experiences and things that happened way too long. It's like a bottle of wine kind of conversation, not a webinar, but it was my platform really is I believe that people will make better decisions when they have all of the options available. And so if they're more educated, they're going to make better decisions. And with the TBI clients, that's where like I love the synergy that you bring to the table, and then bringing in the families and stuff like that. So I think that that's super, super important. I wanted to just go back there were a couple questions that came in. One was just understand what is a life planner, but life care planner. So would you want to explain that just a little bit for the audience?
Sure. And it's not, I see that question. It's not a life plan, it's a life care planner. And so that is someone, oftentimes there'll be a certified life care planner, there's a certification for it. Sometimes there'll be a case manager as well as a life care planner, which gives them a little bit of a different perspective of case managing this type of catastrophic injury case and making sure they don't miss anything. Most times they're an RN as well, which I think, makes them a little bit more credible when they're testifying as to your client's needs, should you need them to testify and defend their plan at some point, which happens in the civil side, but not on the comp side. A life care planner's job essentially is to take all of the medical records that you've obtained through the pendency of the case, whether it's from treating physicians, from experts, and kind of quantify it in a life care plan. it kind of looks like a cost projection of any and all medicals your client might need for the rest of their life. The ones, the life care planners that I use usually will have it's a template that looks like, it'll give you a summary of what's going on with your client. It'll give you their life expectancy based on the life tables, and then it'll say, neurological visits, this many for the rest of their life, psychological visits, this many for the rest of their life, and then it'll go through medications. And then lastly, and most importantly, it'll go through, any sort of custodial care that they might need, any special medical devices they might need, how many projected, hospital visits throughout the course of their lifetime, acupuncture, anything and everything that's been suggested for your client, in cases involving quads and paras, an exoskeleton, anything and everything to cure or relieve your client of the symptoms of their injury that they might need should be quantified, so that you're walking into mediation or trial educated on exactly the value of your client's case, so that you don't accidentally undershoot and expose yourself to malpractice liability and sell your client short by leaving money on the table. So you should obtain a comprehensive life care plan depending on who your life care planner is. They can cost anywhere from $5,000 to $10,000. If you're just getting a cost projection, sometimes they're closer to like $3,000. But it really is an invaluable tool, and one I would recommend you don't do without on brain injury cases.
And I tag into that because that is what really helps to put the why to the plan. So when we're putting an annuity plan or putting the long-term plan together, and they're like, let me just do this and this and this. I have a client right now that I'm working with, and we were able to keep them because there was a workers' comp and a liability side to it. And technically there's a guardian ad litem. But the judge actually went ahead and signed off because we did a special needs trust. But the family immediately, let's go buy a $2 million house. I'm like, no, it doesn't work that way, because my conversation with them is showing them the life care plan, that these are future projections, because it's really hard for people to think through well, I have money now and live life now versus what do I need long-term, instead of Traci just being the person or Tina being the person to say, right, you need to miss this to last. There was a professional that was brought in. In this particular case, the same life care planner can actually stay involved as a nurse care manager. And so that kind of helps as well, because they've already met the person. And so, that kind of helps it kind of transition. Before we go, because we're getting close to the end, because we just have a couple minutes, I wanted to switch, because we didn't get a chance to talk about your Brain SoCal. And as people on here really, I think if they want to see you, talk to you, I know that you're open to just call her because you're so accessible.
Anytime, yeah.
So tell us how you're able to help some of the people that want to learn, and also the Brain SoCal.
Sure. So feel free to share my email address, ojagianlaw.com. I see it's up there, but I'm Tina at Ojagian Law. And feel free to reach out. I'm happy to share, pleadings or anything that you might need, or just discuss a medical plan or a care plan on one of your cases, or if you just kind of want to brainstorm, feel free. It might take me a few days to get back to you sometimes, but I'm very accessible, and I'm happy to help however I can. So I started a nonprofit organization with some of my favorite colleagues about 2 years ago called Brain SoCal, about a year and a half ago actually now. And I've got some of my favorite, most prominent trial lawyer colleagues on the board of the organization with me. And what instigated that was I was taking a look and seeing that, all things held constant, we had these brain injury cases where, the result would so dramatically be varied depending on who was handling the case and their resources and their skill set. Whereas with soft tissue cases, that's not really the case. The value of an orthopedic case and a soft tissue case is pretty much, had a little, a range, if you will. And with brain injury, it was so different, and so just kind of all over the map. And I thought that we really needed an organization down here in Southern California, where we have a huge brain injury, traumatically brain injured population, and cases to kind of help educate our colleagues, provide resources to our colleagues, source the most up-to-date technology and medical experts to come out and kind of teach us and help us raise the bar industry wide. We had our first inaugural conference in October of last year at the Biltmore. We had 800 people show up.
Successful.
Yeah, it was really amazing. And, we did very little marketing. We pulled it together in 3 months, but we had some really prominent speakers, and we got some great feedback on individual stories of attorneys whose, cases were positively impacted as a result of attending that conference. This year, because of COVID, we've just done a few webinars here and there, but we are already putting together the lineup and the program for next year. It'll be October. Gosh, I don't have the exact dates. I should, but you can go to brainsocal.org to learn more about that. We have, I think, early bird registration open already. It's a 2-day conference. It's going to be at the Marriott LA Live, and I'm really excited about it. All of the TBI experts that you want to know and you want to hear from will be there, speaking, exhibiting. All of our colleagues who we all respect, who have had outstanding results and traumatic brain injury litigation will be on panel speaking as well. So I encourage you all to come. We would love to have you. And yeah, and Traci will be there too.
I will be there. I will be there. In the meantime, if you just give myself a terrible plug, is if you don't know the things that I touched on, I actually created this book during COVID and said, this is the cliff notes. Do I need to protect myself? What do I need to protect myself? What are those pitfalls? It's here. It's free. You have it. If you have a client who doesn't want to have a conversation, what you can expect when expecting a settlement. I wrote this for attorneys to give to their clients. It's online. I can send a link to read it, or somebody can read the book themselves. I send it again out for free. But again, you've gotten a book, you've gotten all the material, and so you should do good. And then your clients will be so excited with this too. So again, the inaugural, this was successful. I am super excited to have you, Tina. And
thank you so much. It's been a lot of fun. I appreciate you
with us today. Thank you. I appreciate it. All right, have a great day. Thanks
Take
all.
care, everyone. Bye.